Welcome to the Deep Dive. Today, we're getting into something really critical in business, litigation strategy.
That's right.
You, the learner, sent over a great piece, Understanding Litigation and Litigation Strategy, by Nisha Dindor at Cognitive Market Research, just out this September.
A very timely source.
So our mission here is to pull out the core ideas, sort of demystify it, and give you a solid handle on how companies deal with legal fights.
Yeah, whether you're maybe facing something yourself or just want to understand business risk better, or maybe you're just curious how it all works.
Exactly. Let's jump in.
Okay, so first off, what's the real point of all this? I mean, it's definitely more than just what you see in courtroom dramas on TV.
Right.
Fundamentally, litigation strategy is about, well, managing legal problems efficiently and resolving them in a way that protects the company's interests. You know, it's money, it's reputation, everything.
So litigation itself is the formal process when talking hasn't worked.
Exactly. Negotiation, mediation, if those fail, litigation is the structured legal path.
And why do businesses need it? The source mentions things like enforcing contracts, right?
Yeah, making sure people stick to their agreements, also protecting IP inventions, brands, that kind of thing, and crucially, defending against accusations that could, really hurt the company.
So having a defined strategy,
Yeah.
that's about trying to get the best possible outcome, being prepared.
Precisely. It involves meticulous preparation, looking hard at your case's strengths, its weaknesses, figuring out the odds of winning.
And the potential fallout, financially and reputationally.
Absolutely. And deciding, when does it make sense to settle versus going all the way to trial. Choosing the right lawyers is part of that too.
Makes sense.
Ultimately, the goal is always the best result possible, whether that's a clear win, avoiding a bad loss, or finding an acceptable settlement. It's about defending assets, rights, and your position in the market.
Okay, so beyond just damage control, is there a kind of strategic advantage a business gets from being known for having a good litigation strategy? Like, does it help them otherwise?
Oh, that's a great point. Yes, absolutely. If you're seen as well-prepared and strategic, it definitely strengthens your hand in negotiations, even outside of active lawsuits.
How so?
Well, for one, it might deter others from bringing weak or frivolous claims against you in the first place. They might think twice.
Like a deterrent effect.
Exactly. It also sends a signal to the market competitors, partners, that you're serious about protecting your rights. That can actually boost your standing in business deals.
Okay, that makes a lot of sense. It's like having a strong defense builds confidence overall. So if a company does end up in a legal situation, how does this process actually play out? Walk us through the steps.
Sure. It generally follows a pretty clear path. It almost always kicks off with a pre-litigation evaluation.
Before any papers are filed.
Right. This is super important. You're assessing the merits. Does the case have legs? What are the risks? What might it cost?
So gathering information, looking at old cases.
Exactly. Reviewing precedents, trying to gauge the probability of success, really doing your homework.
Okay, that sounds critical. And once they decide to go ahead?
Then comes the formal step, either filing a complaint if you're starting the lawsuit, or responding to one if you're being sued. That's when it officially enters the legal system.
Right.
After that, you move into discovery. Now, this is a really significant phase.
Discovery. That's the information exchange.
Yes. Both sides share relevant information and evidence. Think document requests, depositions where people answer questions under oath outside of court.
So you really learn what the other side's case looks like.
Precisely. It helps identify strengths, weaknesses, and really refine your strategy based on what you learn.
And does it go straight from discovery to trial then?
Not always. There might be motions and hearings. Lawyers argue points of law before a judge, trying to narrow the issues, maybe even get an early ruling on some parts.
Like asking the judge to dismiss the case.
That's one possibility, yeah. If one side thinks the claim isn't legally valid, and all along there's this constant background question, should we settle now or keep pushing towards trial?
That decision must be tough.
It is. It involves weighing lots of factors, but eventually it concludes either with a trial judge or jury decides or a settlement agreement.
And the strategy guides every step.
That's the idea. A good strategy ensures each action, each decision aligns with that ultimate goal of getting the best possible outcome.
Okay, we've seen the life cycle. Let's dig into the building blocks now. What are the essential components of a solid litigation strategy?
Right, the core elements. The source breaks it down nicely. First up is risk assessment.
Looking at the potential downsides. And upsides.
Exactly. What are the risks, the costs, the rewards? This means looking hard at the legal merits, your actual chances of winning, and importantly, the financial and reputational impact, win or lose.
It's a 360-degree view, basically. What's next after assessing risk?
Then comes case analysis. This is where you really get into the weeds, gathering all the facts, reviewing those legal precedents very carefully, scrutinizing every piece of evidence, building a really solid foundation.
Super detailed work. And that analysis then feeds the strategy itself.
Correct. Strategic planning flows from that. Making those big calls. Are we aiming for settlement? Are we gearing up for trial? Who's the absolute best legal team for this specific case?
And planning out each stage.
Yes, planning the approach for motions, discovery, trial prep, every step.
It sounds like managing a major project.
Yeah.
Needs resources, I assume.
Oh, absolutely. Resource allocation is key. Making sure you have the right legal expertise lined up, the budget to cover costs, and the internal people ready to support the lawyers.
And is the strategy fixed once it's set?
No, not at all. The source really stresses this. Continuous evaluation and adjustment. New facts pop up, circumstances shift. The strategy has to adapt.
So it's dynamic.
Very much so. So you've got risk assessment, case analysis, strategic planning, resource allocation, and that constant evaluation. Together, they give you a complete way to manage these conflicts.
Okay, but even with the best strategy, there must be drawbacks, right? What are the limitations here, the potential downsides?
That's a really crucial point to consider. A major limitation, and the source is clear on this, is the cost. It can be incredibly expensive.
Legal fees, mainly.
Legal fees are a big chunk, yes, but also court fees, paying for evidence gathering, expert witnesses. It all adds up, sometimes very, very quickly.
And it's not just money, is it? Time's a factor, too.
Huge factor. Litigation can take a long, long time. Months, often years. That pulls resources, management attention, away from running the actual business. That's a real drain.
Productivity can suffer.
Definitely. And even after all that time and money, you don't actually control the outcome, do you? That's the uncertainty aspect. A judge or a jury decides in the end. You can have the best strategy, the best lawyers, but there's no guarantee.
And it's usually public.
Yes, generally. Court proceedings are public record. Sensitive company information might come out. That can damage the brand, relationships.
Ouch. Even if you technically win.
Right. The source points out that even a win can sometimes bring bad press or damage important business ties long term, which is why, considering alternatives is so important.
Like mediation or arbitration.
Exactly. They often offer more control, more privacy, and can be faster and cheaper. You have to weigh those options carefully against litigation.
So litigation is powerful, but definitely something to handle with care. How does it fit into the bigger picture of managing business risk overall?
It's fundamental. It's really a core part of protecting the company, its assets, its reputation, its ability to just operate smoothly.
A kind of safety net.
A crucial one. When talking fails, litigation is that final structured way to enforce your rights, protect your IP, deal with contract breaches, basically defend your ground.
But you mentioned being proactive earlier.
Yeah.
Is it more than just reacting to lawsuits?
Oh, yes. A good strategy is proactive. It's about spotting potential legal risk before they blow up into expensive lawsuits.
How does that work in practice?
It means understanding the legal environment you're in, having strong internal processes, like, say, really solid contract management so disputes don't even start, or ensuring you're compliant with regulations.
And maybe having plans for how to respond if something does flare up, like early negotiation.
Precisely. Having those response plans ready, identifying risks early, having a plan that can stop things escalating.
Can you give us sort of general example, maybe a company anticipating an issue?
Sure. Imagine a tech company. Their ongoing risk assessment flags a potential patent issue with a new product feature. Instead of waiting to get sued, they proactively get legal advice, maybe tweak the feature, or even approach the other patent holder to discuss licensing before any conflict arises.
Heading it off the pass.
Exactly. That proactive stance, driven by understanding the litigation risks, saves a world of trouble later. It's not just about avoiding the cost of a lawsuit, but also the distraction and potential reputational hit.
And speaking of reputation, that strategic approach helps manage the PR side too.
Absolutely. If a legal challenge does happen, having your legal and communications strategies aligned lets you manage the narrative, control the message somewhat, and hopefully limit the damage to your brand.
So it's about anticipating, preparing.
Yes. Anticipating challenges, preparing legally, and from a PR perspective. It reduces financial risk and helps protect your place in the market.
Let's dig a bit more into those financial risks. The costs seem like such a critical piece of the puzzle.
They really are, and they're layered. The source talks about direct and indirect costs.
Direct costs being the obvious ones. Lawyers, courts.
Right. Legal fees, court expenses, maybe settlements or judgments you have to pay. And like we said, these can balloon, especially if the case is complex or drags on. Plus, costs for experts, depositions, discovery management. It's a long list.
Okay. And the indirect costs.
Yeah.
The less obvious ones.
Those can be just as damaging, sometimes more so. Think about management time. Senior people getting pulled away from strategy, from growth, to deal with the lawsuit. That's a huge opportunity cost.
And morale. Does that take a hit?
It often does. The stress, the uncertainty, it can really affect employees, impact productivity, maybe even lead to people leaving.
And the reputational cost we touched on that translates to dollars eventually, doesn't it?
Absolutely. If your brand image suffers, if customers lose trust, if suppliers get nervous, that hurts your competitiveness. It can lead straight to lost revenue, lost market share.
So weighing all this is crucial before jumping into litigation.
Vitally important. That early evaluation of risks and potential outcomes informs everything. Do we fight hard? Do we look for a quick settlement? Do we try mediation first?
And planning for the costs.
Yep.
Budgeting, insurance.
Yes, strategic planning includes allocating funds, exploring legal expense insurance options, trying to manage that financial exposure as much as possible.
This has been incredibly insightful. So if we were to boil it down, what are the main takeaways for you, the learner, trying to get a grip on litigation strategy?
I think the biggest takeaway is that it's complex but essential. It's not just legal mechanics. It's a core business tool for protection when other things haven't worked.
Understanding its purpose, the process.
Yes, understanding the goal, protecting the company's interests efficiently, knowing the typical steps from that first evaluation through to the end, and, critically, appreciating the limitations.
Especially the costs and the uncertainty.
Exactly. Knowing about the high costs, the time involved, the lack of full control over the outcome, that's vital for smart business management and handling risk effectively.
So a final thought then for you, the learner, building on what we've heard from Nisha Duor's work, maybe think about how developing that proactive, strategic mindset towards potential legal issues isn't just about dealing with problems, but could actually be a key ingredient in building your business's strength and resilience for the long haul. Something to definitely consider. Thanks for joining us for this deep dive.